just check all the tech is in order, and then we will get started. Great. So, welcome everyone to with myself, Christian Harris, and got a really great guest, Kevin Bridges of Pinson Masons. I'll ask Kevin to introduce himself in a moment, but we're going to be exploring the health and safety legal landscape with Kevin today. He's a real expert, as he'll tell us about in this field, and there should be an opportunity to ask some questions at the end as well, depending on how well Kevin and I go through all of our questions and conversation. Just to be clear, though, although Kevin is a lawyer, he's not here to give free legal advice. You don't find, my wife's a lawyer, and you don't find many lawyers giving free legal advice. But we can talk about, trends and what's happening and so on. But let's not be asking anything too specific. So with that, Kevin, perhaps you could start by just giving a quick introduction to yourself.
Sure, thanks, Christian, and thanks for having me today. And good to see so many people joining. So Kevin Bridges, not the comedian, I'm afraid, the Glaswegian comedian, but partner at Pinson Masons, head of the health and safety team at Pinson Masons, based in the Manchester office, but my role is a national one. I have been a health and safety solicitor for, I'm not going to tell you exactly how many years, because that will potentially give away how old I am, but for more than 25 years, I've been practicing as a health and safety lawyer, and I've done that from day one. I am a criminal health and safety lawyer, not a civil personal injury lawyer. So don't ask me any questions about civil personal injury. I'll have a go at answering them, but that's not what I specialize in. It is in the criminal law. I'm also a chartered member of the Institution of Occupational Safety and Health, and a former vice president of IOSH as well as being a council member for a number of years, but not in more recent years. And we represent clients, corporates, companies, and individuals who are facing the risk of prosecution or dealing with their risks proactively. We support clients both proactively and reactively in helping them to manage their risks and get their control systems in place that are compliant, as well as dealing with incidents when they happen. So that's for both companies and for individuals that may be subject to regulatory interest. So that's a little bit about me.
Fantastic. Thanks, Kevin. And yeah, really delighted to have you with us today and to share some of your experiences and insights. So let's start with, obviously you focus on the UK. We do have some international people in the audience, but we're going to be focusing on the UK. And in the UK, we've got the Health and Safety at Work Act, which turned 50 this year, and still very much regarded as a gold standard in health and safety legislation. Certainly when I speak to people internationally, they often speak about the fact that we've got this great legislation. How would you say that that's managed to stay relevant, bearing in mind the world is so different now than it was 50 years ago? And what do you think is on the horizon in this kind of space in the next year or so?
Sure, thanks, Christian. Yeah, it's a good question to kick off with, because the Health and Safety at Work Act, as you say, has been around now for just over 50 years. Came into force in back end of 1974, and I've always maintained, I have to say, that it's probably one of the best and well-drafted pieces of legislation that I've come across. I can't say that about everything, particularly RIDDOR, which I think is probably the worst piece of legislation I've ever seen drafted. But the 74 Act is a well-drafted piece of legislation and makes it very clear what people's duties are in order to comply, and sets the right framework. So, but you're right. The world of work has changed dramatically over the last 50 years and continues to evolve rapidly with new challenges, climate, sustainability, gig economy, hybrid working, some of these things we may talk about during the course of today's session, artificial intelligence, for example. So keeping pace requires new ways of working as technology changes and people's society changes. And whilst we will see, and we have seen new regulations that are introduced to meet some of those changes, the Health and Safety at Work Act has really remained the cornerstone of health and safety law over the last 50 years. And I think will continue to do so. Why change something that isn't broken? And I don't think it is broken. It was designed with flexibility in mind, which has allowed it to adapt to the changes in which people work and to emerging technologies. And it's not just the Health and Safety at Work Act, but you kind of have to consider the 74 Act alongside the management regulations as well. Now, they came later, except originally in 1992. But when you take the general duties under the 74 Act with Regulation 6, Regulation 3 and Regulation 5 of the management regs, requirement to carry out risk assessments, and then put in place a safety management system, we've got a really strong legislative framework in which to work and to manage risks across the board. The Health and Safety at Work Act can pivot and to address emerging risks. And when you think about what underlies the Act, it's really the standards, approved code of practice and guidance that kind of backs that up in terms of what's expected. So risk, reasonable practicability, that's kind of embodied within the 74 Act, and then risk assessment and the management systems that are required is really what has allowed the 74 Act to stand the test of time. I like to think of risk assessments as being that sort of blueprint for action. It's really important not to forget the significance of what risk assessments can do in terms of managing risks, foreseeing risks and managing those risks. So they're very much the blueprint for action. So when you take the 74 Act alongside the management regs, I think that's why the legislation has kind of maintained its relevance and will continue to do so, addressing these ongoing risks and technologies and changes in the way in which people and businesses will work in the future.
Yeah. And we'll definitely pick up on some of those kind of changes and trends as we get into the conversation. One thing I was keen to pick up on was, obviously we've had a new government in the UK, and there's this focus on economic growth and talking a lot about trying to, I don't think deregulate is the word, but sort of deconstrain slightly certain regulations. To what extent is that relevant in health and safety, do you think? And they've particularly spoken about addressing people with long-term health conditions, and they seem to be looking to employers to take on some of that burden. Is that something we should be concerned about? What should we be doing as employers in that space?
Yeah, no, it's very, very important, I think, to watch what the government are doing and are trying to achieve. And there's a lot of talk around deregulation, not so much in terms of there being fewer pieces of relevant legislation, but trying to encourage people to return to work and to avoid people from becoming sick in the first place. So just to give it some context, the government in January of this year kind of released its white paper, Getting Britain Working white paper, and that's really focusing on the sort of the economic inactivity that exists across the UK in relation to ill health. And at the same time, they launched sort of an independent review into what employers can do to prevent people from becoming unwell at work and for creating and maintaining a healthy and inclusive workplace. And that's really what is at the heart of what the government's trying to achieve, trying to encourage employers to take on some responsibility to ensure that the workplace is healthy for people. And that consultation, I think, is review is expected to go on until the autumn. And they referred as part of that to the HSE statistics. I'm not going to rehearse those, but we know from the statistics that the HSE publish each year, a considerable number of people are out of work because of experiencing work-related ill health, stress, depression, anxiety, etc. So they kind of referenced all of that. And both the agency and the government are really both committed to improving these statistics. And the focus for them is very much on mental well-being, respiratory disease, musculoskeletal disorders, so moving and handling, as well as exposure to such things as noise and vibration. So we can expect that that is going to influence, I think, what the HSC's activities are going to be and other regulators' activities are going to be. And what part of the focus of the HSC's priorities and its business plan is that they very much want to focus on employers' occupational health services and their arrangements for health surveillance. So where that's relevant, that really is an area where I think the agency have said, well, it's just not good enough. And so they want to focus their attention on that. So I think they do want to raise awareness of these things amongst employers and encourage employers to do more to prevent people from being off work sick and to encourage them to come back to work. I think some of the challenges, and I'm not a believer in enforcement action being the driver for compliance, but I think the reality is that in the absence of any structure around bringing enforcement action, there is a tendency that things don't reach the top of the pile in terms of the priorities. And so occupational health is an area where there hasn't been a great deal of enforcement action over the years, and so we may see that may be changing in the future.
Yeah, no, that all makes sense. So certainly something we should have on our radars if we're managing risk and safety in our businesses.
Yeah, absolutely.
Yeah. Another sort of big happening recently is obviously the final report on the Grenfell tragedy and the inquiry reports. And it looks like this is going to bring quite a lot of change, particularly around construction products. What can we sort of expect there? Because that's something that's been on the government's agenda for a while now.
It's quite a specific niche kind of area, but it's worth just touching upon briefly because there's a couple of aspects to the Grenfell inquiry recommendations, and we've seen many changes over recent years to the regulatory landscape on the back of the Grenfell tragedy. And construction products has clearly been a key part of the inquiry's recommendations that were published at the end of last year, and which the government have recently responded to and said that they're going to implement all of the recommendations that the inquiry have made. And one of those is in relation to the regulation of construction products, because that it has been in need of reform for many years. Many construction products rooted fall outside of the current regulatory regime. And what that means is that there's no regulation around both the quality and the safety of those products. And that's been recognised by the government as an area where they need to close the gap. So what they're proposing is really quite ambitious. It's quite far-reaching. They're proposing a much tougher regime with a new proposed regulator, construction regulator, as well as changes to the law in relation to construction product safety. So it's going to be risk-based. It's going to be, this is what the noise is anyway, and it's going to address all of those products that don't currently sit within the regime. And it's going to cover the whole life cycle, both from the manufacturer and supplier of products to also builders, contractors, and those installing construction products. So there'll be obligations, it's expected, on each of those duty holders to ensure that construction products are safe to use, to supply and use, backed up with this tougher regulatory regime. So we kind of need to wait to see exactly what that will look like. But yeah, it's certainly something that the government are looking to push through and enhance the safety of as-built buildings. We've seen the Building Safety Act as a result of Grenfell. That's kind of one aspect of that, but this is where they're now focusing their efforts to again enhance the overall safety of as-built buildings when they're constructed.
Yeah. I'm sure something that we can all get on board with the principle of. There's something else which seems like a likely development in 2025, and that's the protect duty. What is that, and how is that going to impact on businesses?
Yeah, so the protect duty, its proper name, its official name is the Terrorism Protection of Premises Bill, currently making its way through Parliament. Was introduced to Parliament last autumn, end of the summer, September 2024. It's another example of where government has introduced legislation in response to major events, and this is around terrorist threat of risk of terrorist attacks. So the aim is to reduce the risk of terrorist attacks by requiring certain locations, premises to implement enhanced mitigation measures to address the risk of terrorist attacks. And it's more commonly referred to as the protect duty because it imposes statutory duties on qualifying premises and qualifying events to take action in the risk of that potential of a terrorist attacks. And the degree, it's a tier-based system for eligible locations, which is basically any land or building premises where members of the public have access. So it will be broad ranging. It will cover entertainment venues, retail spaces, museums, sports grounds, visitor attractions, temporary events. It's very, very broad of its scope, and will apply based on the occupancy levels of the premises. So the two tiers will be standard and enhanced. Standard tier is for those that have an occupancy of 200 or more. It was originally 100, that's gone up to 200. And the House of Lords at the moment are saying it's going to stay at that level. So 200 or more standard tier and 800 or more for the enhanced tier. And what will be expected will depend on the size of the premises. It's going to be interesting in terms of how this is regulated. It's going to be the Security Industry Authority that will monitor and enforce compliance. The enforcement regime will be both criminal and civil in nature. There are some concerns about exactly how this is going to, what this will mean in terms of the compliance with it. And further guidance is promised, which will hopefully assist in terms of how one complies with it. But just to be clear, this is, whilst it is a new piece of legislation and therefore a new duty, I don't think actually what it will require goes beyond what we already have. The risk of terrorist attacks in public spaces isn't new in my view. It is foreseeable. It's already covered by the duty holders' obligations under the 74 Act. Section 3 of the 1974 Act requires you to think about foreseeable risks to members of the public. Terrorist attack falls within that. So it's already covered really by health and safety legislation and the need for you to carry out a risk assessment under the management reg. So I wouldn't be daunted by this. It is just an extra layer to think about and to perhaps revisit your existing risk assessments where you fall within scope to make sure that they do properly, your risk assessments and your control measures do properly take account of this specific risk of terrorism.
Yeah. That's quite comforting actually, because I know in my conversations with people about this, there has been quite a lot of worry about, how far-reaching would it be and how burdensome and cumbersome would it it be to meet the requirements? So if you're saying that actually it seems likely that it's not going to be adding too much, then that's probably quite a comforting thing for the audience.
Yeah, yeah.
Good stuff. Obviously, things like terrorist attacks and something like Grenfell leads to public inquiries. Often, we're going to see that with the Southport
Mm.
incident and COVID and so on as well. And the Grenfell inquiry in particular has led to a renewed confirmation of additional duties on public officials about public inquiries. How could this impact on businesses?
Yeah, well, it's still very early days. This is what's generally referred to as the Hillsborough law, and we haven't yet seen a draft bill. So this is all kind of bit of blue sky thoughts around this. But the idea is that it will attempt to re redress the perceived imbalance, that inequality of arms between the victims of disasters and scandals and public bodies, particularly the police, I have to say, is really where a lot of this focus has come. As you say, it's in response to the Grenfell inquiry recommendations. So, again, Grenfell really kind of driving a lot of these changes. And it's expected we're expected to see draft legislation before the anniversary of Hillsborough, which will be on the 15th of April. And the idea behind the law is very much to introduce what's known as the duty of candor, and that's really just a legal obligation to be open and honest. We're seeing, as you mentioned, a lot more public inquiries. There's quite a call for them, and the government is generally responding positively in opening public inquiries. So this duty of candor, this duty generally on public officials to be open and honest is potentially quite significant. And it will be a criminal offence to fail to properly cooperate with those investigations. The idea being to improve accountability and transparency. Um, but will it only extend to the public sector? I don't think that it will. I think it's likely that it will also be broad enough to bring into scope private entities in certain circumstances. And those circumstances are likely to be where either public services have been delegated or passed on contractually from a public body to perform to a private entity. They're likely to be caught in scope, or where private entities owe a health and safety obligation already to the public or to a member of the section of the public. So if you're putting on a sporting event or leisure and entertainment events, then this duty of candor is likely to catch you as well as public sector organizations. So it's still a bit too early to say really with any degree of conviction how far each of the legislation might be. And to the extent to which it will apply. But I think it is likely, I strongly expect that it will impact both private and public sector. And so just being vigilant about that and making sure that you are proactively managing risks, because what you won't be able to do is shy away from those later if things go wrong and you're embroiled in an investigation. So really, again, just being proactive.
Yeah.
And so this duty of candor won't be something to be worried about because you've got nothing to hide, and so there's no problem in being open and transparent. But yeah, that's the intention behind it, to readdress some of that imbalance and inequality of arms that's perceived to exist between victims of disasters and those that are responsible for them and for investigating them.
Yeah, yeah. And often what comes out is if you're doing the right things, then you shouldn't have anything to worry about here. If you're managing your risks right, if you're being proactive, etc., then there's nothing to fear. But obviously, this is designed to um, affect those people that are less likely to be doing the right thing. So yeah, that's why we should be supporting
Precisely. Yeah,
these changes, I
precisely
guess.
right. Yeah.
If you're with us, yeah, yeah, yeah. Do think about any questions for Kevin. I've got a few more things to ask him about, but then we'll probably have some time to ask some questions as well. So feel free to pop something in the chat, or you could at the appropriate time unmute as well. Kevin, one of the things that's had a lot of publicity, what would it have been now? 9 years ago was the changes to the sentencing guidelines, where we saw quite a sharp increase in the bandings for criminal fines, and the effect of that has been a larger number of larger fines for larger organisations. The Sentencing Council has recently consulted on potential revisions for that. Could you give us a view on what might happen there with any changes and how that could mean the courts are approaching sentencing in these criminal cases?
Yes, yeah, it's unbelievable, isn't it, that the sentencing guidelines have been around now for 9 years. February 2016, they came into effect. And as you say, they very much have changed. For a defense lawyer like myself representing clients that are sometimes convicted and fall to be sentenced, these guidelines are mandatory in England and Wales. So it's important that we are aware of them. Now, I'm not sure from those on the call what sort of size organizations they come from or maybe supporting, but yeah, there are micro. The guidelines are provide tables for the sentencing of micro, small, medium, and large organizations. And they're pretty well established. And as you say, we've seen increased fines. What the Sentencing Council have recently been consulting on is nothing to do with micro, small, medium, or large companies. That's not going to change. What they are focusing on is very large organizations where there's practically no guidance whatsoever in the sentencing guidelines as they currently stand. There's a table, there's a little box above the large company table, which says that where a company's turnover very greatly exceeds the threshold for a large company, that threshold being 50 million, then the courts can move outside the range for a large company to achieve a proportionate sentence. Over the last 9 years, the Court of Appeal have grappled on numerous occasions with when is a company a very large organization or VLO, and when it is a VLO, what should the sentencing court do about it? Where the Court of Appeal have taken us is not very far, because they have said you'll know when a very large company, when an organization is a very, very large company, you'll know it when you see it. Well, that's not very helpful. What we do know is that organizations that turnover is about 250 million upwards are very likely to be considered VLO, but that's not determined by the Court of Appeal, and these guidelines aren't going to change in a way that will actually confirm that. But for those in the room that are sort of wondering, well, where does the VLO status start? It's probably around 250 million, and the closer you get to half a billion upwards, you're definitely in VLO status. So that's the sort of, but the guidelines aren't going to make that any clearer. You've just got to rely on what the Court of Appeal has said. And then what does the court do when you are in that bracket? Well, again, the Court of Appeal have endorsed various approaches. Some courts have doubled the starting point. So if you determine what the starting point should be for a large company, if you're a very large organization, let's double it. Other courts have adopted a different approach and said, well, we'll take the starting point as if you were large and we'll just move up within the appropriate range. So there's been no certainty as to the way in which the courts are approaching this. And the guidelines that are likely to change are simply endorsing two things. One, that there's no obvious threshold at which a company becomes a very large organization. We already know that. And secondly, that there's no mechanical or mathematical formula that the court should adopt if you are a very large organization in order to reach the the fine. So it's there. It's something to be aware of, particularly if you are supporting or advising and working within a very large organization. But it's still going to mean that the courts are going to have a huge discretion, will retain a huge discretion in terms of sentencing under the guidelines for these substantial businesses.
Mm-hmm. And where have we sort of fallen on this? So, if you think about somebody like the big supermarkets who obviously have suffered from some fines I'm aware of over the last 9 years, and you look at them and the fines they've received as a portion of their turnover, let's say, versus a £50 million company in that large banding. Has it been sort of proportional, or has it been sort of perhaps arguably a little bit soft, or where would you say that's been so far?
Yeah, it's a really good follow-up question, actually, because when you think about the fines that we've seen, so similar guidelines for environmental offences, and we've seen fines under the environmental sentencing of £20 million against utility companies. The health and safety sentencing kind of falls into insignificance compared with that. We've not seen fines north of 10 million for health and safety, let alone 20 million. So I think it's fair to say that and I've been somewhat surprised that we haven't seen multi-million pound fines for those organizations that have a very large turnover. Now, that's not what I've not commented on today, is that turnover is part of the equation. There's then the question of how profitable those organizations are. But we have seen, as you said, lots of organizations sentenced who have a very large turnover, do have a good profit, and the fines are still relatively low when you compare them with environmental. Now, I think that may change. I think part of the legal fraternity that I'm part of do believe that the guidelines, if they're changed for VLOs, might see an upward shift in the overall level of fines, and if they go up, then that may drag everything up. So we may see over the coming years a slow increase in the levels of fines, but certainly I think the potential is there, and it very much comes down to the sentencing appetite of the court in terms of what sort of message they want to give. But it's fair to say I have been slightly surprised that the guidelines have been enforced now for 9 years, and we haven't sort of seen significant fines that are closer to that £10 million mark, which is good for many businesses who feel that they don't want to receive those fines. But yeah, it is somewhat surprising.
Yeah. 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 I mean, the point about profit is obviously really relevant as well. I mentioned the supermarkets. The supermarkets have massive turnover, but their margins are very, very thin. So therefore, they're making arguably less profit, proportionally than a business that might be turning over 100 million but doing something with much higher margins. So you've got to
retail and sort of construction industries, so fairly high turnover but low profits. It is a relevant factor as to why fines may be somewhat lower than we perhaps think they should be, or on the face of it might have been.
Yeah. Greg in the chat here has said, my experience is that most courts use mitigation as a reason to keep very large companies within the large company banding within the sentencing guidelines.
Yeah, and in factual experience, I don't disagree with that. I think strong mitigation can sometimes do that, and the courts are at liberty to say, look, I could consider you a very large organization, but actually in the circumstances that I've heard, mitigation being part of that, I am going to treat you and apply the large company table, and think that is reasonable to continue to use and apply for the having heard all the submissions that I've heard. So yeah, that's a good observation. Thank you.
Something else that happened 9 years ago. I think I'm right. I think it was 2016. It's a long time ago now. It was Brexit. And obviously we've the regulatory approach, the regulatory environment continues to evolve since that happened. Do you see any particular areas of health and safety regulation where the divergence away from the EU rules and regulations could present opportunities or potentially challenges for UK businesses?
I do. I think it's both. Actually, I think there has been opportunities. It's surprising how long Brexit was ago, but we're still seeing that kind of emerging fallout from that. So I think there are both opportunities and challenges. The opportunities, I think, is well. Let's also just put into context that many of our laws, 74 Act, which we kicked off our conversation talking about, predated our involvement in the EU. So we kind of set the pace with that 1974 piece of legislation that we've talked about, stood the test of time, still relevant today. Corporate manslaughter legislation, so the Corporate Manslaughter Corporate Homicide Act, independent of EU. Fire safety legislation, independent of EU, and always has been. So we've seen that we have always been flexible and will have our own laws independent of the EU. But it's right to say that the six-pack back in 1992, which was pretty much early days of my career, were all derived from Europe, and a large number of our regulations remain derived from EU directives. They've been tinkered with, but there's been no major overhaul of that, and I think rightly so from my perspective. Yes, the government's kind of looking at deregulating and reducing unnecessary red tape to boost economic growth. But I don't think health and safety falls into that category. I don't think UK workers or the HSE really want to see an erosion of our health and safety laws that are derived from Europe. But what Brexit does do is to give us that opportunity to regulate when we want to regulate and not have to consult with or be aligned with our European partners. Examples of that are in relation to AI, for example, where I think the EU are taking a more prescriptive approach to managing artificial intelligence and what sits around that, whereas the UK's approach is a little bit more pro-innovative and allowing existing regulators to put guidance in place and to do that. So that creates opportunities that we can do our own thing that suits our business communities and environment and society, not be constrained. And we've seen that with Protect Duty and the Building Safety Act, good examples of where, in response to events in the UK, the governments have legislated for it. There is a flip side, and I think there are challenges in that the divergence of regimes are such that for those organisations that are operating both in the UK and in Europe, or are exporting to Europe, that divergence does, I think, add cost, does add complexity. Because whereas before perhaps you were complying with a single regime that was European-wide, the further we move away or unpick some of those regulations that have existed over many years, or introduce new legislations that diverge from the position in Europe, for certain businesses, I do see and accept and recognise that, that does add to the complexity, the red tape, and the costs because of that divergence. But I think that was the whole purpose of Brexit. One of the purposes was that sovereignty to legislate when we need to legislate. We have always done that. I think we'll continue to do that.
Yeah, no, that makes sense. Last two or three things I wanted to talk to you about, and one of them you just picked up on, which was technology. So we've got a lot going on with AI, automation, wearables, lots of safety technology that's coming around and being developed all the time, which again present opportunities and potentially risks. How should we approach this from a legal perspective? What are the sorts of things we need to consider when we're integrating these types of technologies into our businesses?
Yeah, so all this technology is I'm not a particularly techie person myself, but I've got to kind of grow up and get with it as I keep getting told. So I think it's important that we do kind of acknowledge that AI is here to stay, automation, this technology is all here to stay, and it can be a real game changer, I think, for workplace health and safety. They can help with everything from performing hazardous tasks and therefore de-risking by technology performing those tasks, as well as monitoring kind of safety and conditions and gathering data. So there's a whole breadth of things which is really quite important and valuable. But legally, what we must do is understand and mitigate the risks associated with these technologies in order to both fully kind of maximize the benefits from them, but also deal with any potential legal pitfalls. And I don't see that we're going to have new regulations for this. We're going to have to go back to the basics, Health and Safety at Work Act, Regulation 3 of the Management Regs, and apply that to these new technologies. Personally, I think that's okay. I think we're all well equipped to do that. But some of the things just to think about, mental health is one. AI, whilst having a great potential impact to drive efficiencies in business and in safety, can also be a cause of great concern, anxiety. So employers really do need to think about how is AI going to impact on our workforce? What legal obligations do we owe to our workforce in introducing AI to give them that reassurance that it's progressive and positive rather than a negative. And then sort of using AI, so that's about AI in terms of perhaps driving efficiencies in business, which may have an impact for employees. But AI being used to, for example, gather risk data using drones for site inspections, great potential, but also potential risks around the safety of that equipment, its regular maintenance, its testing, making sure people are properly trained to handle it. And then when we get the data from that, what do we do with it? The idea being you gather that data, that gives you information about risks, what are foreseeable risks, you should act upon it. The danger is where you're using all this technology, and we've seen this in cases where CCTV is perhaps not being deployed in the right way, and then it's captured an event and is then being used against the organization as evidence of not actually responding to what is obvious. And if you've monitored performance, what would have been obvious. Same with the use of data that's gathered using AI or technology. What are you going to do with it? You've got to be prepared to respond to that, because otherwise I think it's likely to failure to do so is likely to have a very negative impact. So I think that it's a really important area. We've all got to get up to speed, even me, with it and embrace it, but realize that there are challenges around using it. So both making sure we risk assess its use, that it's safe to use and it's deployed appropriately, and then responding to the information that we gather. So I think those are some of the legal issues around these emerging tech.
Yeah, very, very interesting, particularly the latter point. And I wonder where this will go in terms of the kind of head in the sand defense to something. I didn't know about that, so therefore I couldn't have done something about it. Obviously, they'll reach a point, I guess, where the technology is so widely adopted that it would be expected to be reasonably practicable that we would have this kind of thing in place. And does that sort of produce a potential challenge?
I think you've hit the nail on the head there, because it's not just what you ought to know about. It's not just what you know about, it's what you ought to know about, and where you're using technology, but misusing technology. The example of CCTV, where that's capturing unsafe behaviors that you're not responding to, then that can be used. Again, I am a defense lawyer, and but I don't want to say that enforcement is the driver for change. But the reality is, when often I am involved in supporting clients, it is when an accident's happened, it is where a riddle's gone in, it is when a regulator is investigating and calling for evidence and call for the CCTV. And when you sit and watch that CCTV over the hours before the event or over the weeks preceding that, it's all there, it's captured. What is corporate knowledge? That you were on risk, you're on notice that these unsafe behaviors were taking place, and what did you do about it? You can't really argue it wasn't foreseeable in those circumstances. I think it's a real risk. It's a real positive, but being aware that, yeah, all this information is out there, and the more information you're gathering, that is all part of the corporate knowledge, and needs to be properly processed and acted upon. And if it is, it will improve safety. I think that's the key. But it's making sure that you strike that balance.
Yeah. Yeah. No, definitely. Yeah, great advice and thoughts there. Last thing from me, Kevin, and then we'll start to wrap it up. Mental health is obviously something that is increasingly in people's awareness. What do you think is going to happen around health and safety legislation as it pertains to mental health? Do you expect stronger duty of care, more regulations, more requirements around employee mental well-being? How would you advise people to sort of horizon scan and be aware and think about this?
Yeah, mental health is a really important topic area, regardless of which industry you're in. And it's great that it's getting increased in attention. Do I see that there's likely to be new legislation around managing mental health? No, I don't, not from a health and safety perspective. And I think the reason for that goes back to what I was talking about at the very start of our time together, which is the legal framework that we've got in place under the 74 Act, under the management regulations, is more than capable of dealing with mental health as a workplace issue. It is a workplace issue. HSE makes it very clear that it's a workplace issue. It's not universally a health and safety issue. It's not an HR issue. It is a business issue that straddles H&S, occupational health, and HR. And businesses, I think, need to embrace it in that way, that it's a cross-discipline issue, not really. Organizations, I accept, will approach it from different ways. Sometimes in an organization, it's seen more as an HR issue. Other organizations, it's seen more as an H&S issue. My preferred approach is that it's both. And so actually cross-discipline is a better way of managing. So I don't see health and safety legislation as being the way that we will that employers will engage more with this topic area. More guidance, I think, is helpful from the HSE in terms of what's expected. Again, I keep saying I don't believe that enforcement is the driver, the stick to encourage compliance, but sometimes it is. And we just haven't seen any enforcement action in relation to mental well-being. And so for those that I think want to actively participate in the process, guidance is what's needed. Clarity around what's expected and what's not expected. So I think that's what's needed to help and assist those that want to proactively engage. For those that don't want to engage at all, don't see it as a workplace issue, then I think enforcement action is necessary, because I think that's where we've got to be dragging people along with us. But I don't see any changes to legislation. I think it's a growing problem as well. I'm working today in the Manchester office here, but I work from home a couple of days a week. So hybrid work, and that's post-COVID. I was in the office every day pre-COVID. Post-COVID, hybrid working, common in the legal profession. I'm sure it's common for a lot of people that's listening. You either work from home all the time or you have that mix. There's issues around hybrid working in terms of health and safety. I don't think organizations are that well equipped to deal with hybrid working and manage the risks around hybrid working. They kind of ignore the needs to carry out workstation assessments when you're working from home, because your duties to your employees extend to wherever they're working. And hybrid working is becoming much more common and will continue to do so. So as well as that physical issues around hybrid working, mental well-being, isolation. I love being in the office personally. I love meeting colleagues and having a chat and not just staring at the same wall at home. So yeah, that mix is important. But for others, that remote working, hybrid working, or home working can also be that isolating factor. So mental well-being really important in that space, which I think organizations just need to begin to grapple with a little bit more than perhaps they have been doing for whatever reason.
Perfect. Well, thank you so much, Kevin, for joining us today. It's been really insightful, and I've learned a lot. I'm sure others have as well. Before we wrap up, where could people best kind of connect with you or learn more about what you and your team are up to? Is it the website? Is it LinkedIn, etc.?
Any way they like, they can email me, they can contact me through LinkedIn, or that they can find my contact details by going to Pinsent Mason's website or via LinkedIn. I'd be really happy to engage with anybody that wants to. I just saw a comment in the chat there relating about lone working. Totally agree with that comment. Lone working is not something that's really well addressed. So yeah, totally agree with that comment.
Yeah, fantastic. Well, thank you very much, Kevin. I really enjoyed it, and internet connection has been a bit unstable, so I hope that hasn't negatively impacted anybody's enjoyment of this, because it has been very fantastic, insightful content. So I do hope that you got the most out of it.
Thank you, everybody.
Thanks a lot, everyone.